case of the people of the state of Michigan versus Virgil Smith. Appearances, please.
Lisa Lindsay on behalf of the people of the state of Michigan.
Anna Godfrey Diller on behalf of the defendant.
Gerald Evelyn, co-counsel on behalf of the defendant.
Welcome back, Mr. Smith. All right, I guess I'll start by thanking all the parties here. And one of the, because really everyone's been, I wonder whether I should mention this. We've all known one another for a long time, and I think that all of you are advocates for the positions that your respective sides are, and I respect that. And I think that you've all acted, even though sometimes we all get a little testy with one another, which is just part of the process of advocacy. I know I read recently that something that a professor wrote about civility, and that's, he wrote, Professor Steve Carter, he wrote about civility, manners, morals, and etiquette of democracy, which I guess is applicable to us here in the courtroom and also for the broader issues that are here today. And he wrote that civility assumes that we will disagree. It requires us not to mask our differences, but to resolve them respectfully. Civility requires that we express ourselves in ways that demonstrate our respect for others. And I think that everyone's done that. Even when we get a little testy, that's all part of the process. And we all know one another, and so I want to thank you all for that. So I think I should start with the motion to vacate the plea, because that will determine whether or not I have to make any other decisions today. And since I have a tendency to run on too long, I wrote this down and went back and made some revisions, and wasn't sure what I was, after I listened to the parties, what my decision would be, but this is my decision. All right. The defendant is a member of the Michigan Senate. The Wayne County prosecutor charged him with 4 crimes. Count 1, malicious destruction of personal property, the damage or injury being $20,000 or more, a felony with a maximum penalty of 10 years in prison. Count 2, assault with a dangerous weapon, also known as felonious assault, a felony with a maximum penalty of 4 years in prison. Count 3, felony firearm, a felony with a mandatory penalty of 2 years in prison, the 2 years to be served consecutively to and preceding any term of imprisonment imposed for counts 1 and or 2. This crime is sometimes referred to as the one with gun gets you 2. And count 4, domestic violence, a misdemeanor with a maximum penalty of 93 days in jail. The charges are not related to his official duties. On February 11, 2016, the prosecutor and the defendant presented the court with a signed settlement offer and notice of acceptance, which is attached to this opinion and order as Appendix A. The defendant would plead guilty to count 1, malicious destruction of personal property, with the following sentence agreement: 10 months in the Wayne County Jail with no early release, 5 years probation, resign position as state senator, cannot hold elective or appointed office during full pendency of probation, alcohol and drug treatment, monthly documentation, mental health evaluation, full compliance with treatment, monthly documentation, surrender weapon used, full restitution to be determined by the court. In exchange, the prosecutor would dismiss count 2, felonious assault, count 3, felony firearm, and count 4, domestic violence. The plea and sentence agreement, which I refer to as the plea agreement, was put on the record, and the defendant pled guilty. The defendant appeared for sentencing on March 14, 2016. He had not resigned his position as state senator. The court sentenced him to 10 months in jail and 5 years probation, but decided, without being asked by the parties to decide, that the portions of the plea agreement that required the defendant to, quote, resign his position as state senator and not hold the elective or appointed office during full pendency of probation are void. The court stated its reasons for this ruling on the record and in an order declaring void portions of the plea agreement. The defendant has not resigned. The prosecutor filed a motion to vacate plea. Michigan Court Rule 6.310, capital letter E, provides that on the prosecutor's motion, the court may vacate a plea if the defendant has failed to comply with the terms of the agreement. The prosecutor writes, quote, "While the people understand the court's reluctance to order defendant to resign from office, defendant is able to comply with the terms of the plea agreement without a directive of the court. Having not done so, the court must vacate the plea. The people, no less than defendant, are entitled to receive the benefit of the agreed upon bargain." Michigan Court Rule 6.312 provides that if the plea is vacated by the trial court, the case may proceed to trial on any charges that have been brought or could have been brought against the defendant if the plea had not been entered. The defendant filed a response opposing the motion. But in paragraph 10, the defendant refers and quotes a specific section of People v. Siebert at 261 Michigan Appeals, 402, page 431 of 1993. In doing so, the defendant is telling the court, without explicitly saying, and I put this in my quotes because this is my interpretation, quote, "Judge, don't vacate the plea, but in case you decide to do so, please give me the opportunity to resign first, so I can avoid the almost certain fate of going to prison for 2 or more years, and instead serve probation and a jail sentence of 10 months. In People v. Martinez at 307 Michigan Appeals, 641 at page 651 from 2014, the Court of Appeals stated, and I'm not going to read all the quotes in here, or all the citations, I should say, but the Court of Appeals stated and cited other cases and said, "The authority of a prosecutor to make bargains with defendants has long been recognized as an essential component of the efficient administration of justice. The prosecutor's broad discretion in deciding what charges to bring is the underlying basis of plea bargaining. And while analogous to a contract, plea bargains are not governed by the standards of commerce, but must comport with the interests of justice in the administration of criminal laws. The standards of commerce do not and should not govern the administration of criminal justice. Strict contract theory or principles peculiar to commercial transactions may not apply. Thus, the scope of a plea bargain is determined by its terms under principles of contract interpretation, but those terms must serve the interests of justice. In other words, contractual theories will not be applied if to do so would subvert the ends of justice." On March 14, 2016, both on the record and in its order declaring void portions of the plea agreement, the court stated that the portion of the plea agreement that required the defendant to resign his position as state senator and not hold elective or appointed office during the full pendency of probation are void. This portion of the plea agreement is an unconstitutional interference by the prosecutor with the legislative branch of the government and with the rights of the defendant's constituents. This portion of the plea agreement offends the Constitution of the This portion of the plea agreement offends the Constitution of the state of Michigan, is contrary to public policy, and compromises the integrity of this court. Void, as I used it in that order, means that that portion of the plea agreement has no legal force and is not binding. It is not enforceable. In its March 14 ruling and order, the court also stated that the defendant's plea remains valid with regard to the charges to which he pleaded and the remaining portions of the plea agreement. This is because the prosecutor and the defendant assured the court at the plea hearing and at the sentencing hearing that the plea bargain protected the public and provided punishment and rehabilitation. Enforcement of the plea agreement without the offending portions serves the interest of justice. Vacating the plea bargain would not serve the interest of justice for the reasons stated on the record here today, for the reasons stated on the record on March 14th, for the reasons stated in its order declaring void portions of the plea agreement, and for the reasons stated in this opinion and order denying the prosecutor's motion to vacate the plea. Vacating the plea bargain would in fact harm the interest of justice. Vacating the plea would violate the fundamental principle that it is the right of the people to elect whom they choose to elect for office by allowing the prosecutor to pressure a member of the legislative branch to resign or face prosecution and likely imprisonment. Vacating the plea would violate the separation of powers set forth in the Michigan Constitution, where only the Senate can discipline or remove one of its members convicted of this type of crime by allowing the prosecutor to pressure a member of the legislative branch to resign or face prosecution and likely imprisonment. Vacating the plea would violate public policy by allowing the prosecutor to dominate the legislative branch of government with the threat of forced resignation. And granting the prosecution's motion to vacate this plea would compromise the court's integrity by involving it in an act that violates public policy and offends the Constitution. It does not matter that the defendant voluntarily agreed to this portion of the plea agreement, because these constitutional protections exist not for the defendant's personal benefit, but to protect the rights of the defendant's constituents and the right of the legislative branch of government. The prosecutor's motion to vacate the plea is denied. It is so ordered. Okay, we have other business to take care of.
Judge,
Yes.
the second portion of the motion as related to the marijuana testing.
Yes. I assumed that when I gave you an opportunity for argument, you both address that. But if not, you're free to address it now. Ms. Lindsay?
It's in, I briefed it, it's,
Okay.
you can test for it, just not punish them for it. You test for other, a person has prescription for drugs that they're prescribed by a doctor. You test, you don't violate them for that. So I think he can still be tested for drug testing, just not violating the marijuana.
Judge, I'm relying upon the Michigan marijuana statute, which says that you can have any penalty, and as a condition of probation, that has to be a penalty because it's the result of his criminal conviction. So I'll stand on my argument that they can test for drugs, but they can't test for marijuana.
Well, there really wasn't there wasn't a specific citation, I guess, obviously, because we're not aware of it being addressed anywhere else. And Ms. Lindsay is correct that there are many people who are on probation and as a condition of probation are receiving drug treatment and have to submit for drug tests. And they may test, and oftentimes those drug tests screen for drugs that the defendant has valid legal prescriptions for.
But
And I guess the other part as well is I don't know how feasible or practical it is when they're doing these drug screens to tailor them to specific drugs.
But Judge, this situation where we have an actual statute that prohibits that. That's
No,
different.
the statute doesn't prohibit testing for it. And furthermore, how can he comply with the portion of the plea agreement that says drug and alcohol monitoring monthly or testing monthly, how can we know if he's complying if nobody's testing him? So
We're
that
Well, Mr. Gillard is
Not arguing
suggesting that he not be tested.
tested, no.
He's only suggesting that he may not be tested for the presence of marijuana.
That's it. That's correct, Judge.
I don't know if they can do that.
But that's their problem, Judge. That's
No,
not
no,
our
no, no,
problem.
no, 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 no. That's not our problem. And I know he's being very cavalier about it, but I find nothing funny about you agreeing to things and then at the last minute when the judge does something, you try to piggyback on what the judge did. He had no problem whatsoever with any of this before we came in here in court.
I don't want to be guilty of malpractice, okay, Judge? I don't want to be guilty of malpractice, Judge.
How's that guilty of malpractice? You should say what you mean and mean what you say.
All right.
That's the way I was
Let
always
me
raised.
let me back up as well by saying is that I don't really know who started it or who initiated it or who volunteered what portions of this various portions of the plea agreement. It doesn't really matter to me because it had no impact on what my decision would be. But we all know that it's not really an equal negotiation. The power of the people, of the government, outweighs the power of the individual defendant. I can't quantify it. In any event, I think that what I'm going to do, at least for now, and subject to revisiting, if the party's asking to revisit it at a later time, is that I'm going to say, where did I say it? That the defendant must not use any controlled substance unless legally prescribed by a licensed physician, must attend alcohol and drug treatment with monthly documentation, must attend mental health evaluation with full compliance with treatment and monthly documentation, full restitution to be determined by the court. Defendant must reimburse the court of Wayne for each day of jail incarceration at a rate of $60 per day, i.e. 306 days equals $18,360 per Michigan compiled law, 801.93, and no contact with Anicia Thomas, either directly or through a third party. So I'm going to allow the testing for the marijuana. But as long as he's has a valid, as long as he otherwise complies with the order of probation, in terms of controlled substances prescribed by a licensed physician, he's in compliance.
Thank you, Judge.
So that's
Thank
my
you,
ruling
Judge.
on that. And I
All right.
entered it into the order of probation. Let's see here. Oh, yes. Part of the plea agreement was that the prosecution was going to move to dismiss counts 2, 3, and 4 pursuant to the plea agreement. So I guess I'm asking whether or not, and that was unfinished business from last time. And so I'm asking whether or not I hear a motion to dismiss those counts without prejudice. Without prejudice, so everybody knows, means is that it's not like double jeopardy. It means that basically the importance of it means here is that if, for instance, the prosecution were to decide to appeal my ruling and I was reversed, those counts are still valid and the prosecution can go forward on those counts.
That's correct, Judge, and that would definitely be without prejudice.
Okay, so you're moving to dismiss those counts without prejudice?
Correct, Judge.
Okay, the motion is granted. All right, and so what are we doing next?
We're ready to, Mr. Smith is ready to
Begin a sentence?
begin a sentence.
All right, let's see. I think I've got the order of probation that will need to be signed. And I think I already gave him his advice of rights, or at least I orally gave him. I don't recall if we gave him a copy of it, did we?
I don't think so.
No, Your Honor.
We didn't get a
Okay,
copy of it.
but I do recall having done it on the record, so
Correct.
Crystal, if you could get us another advice of rights form.
Here, one more.
Where's one more?
Here, notice of right to appeal.
He just signed it.
He signed the probation order. I advised him of his appellate rights when we were on the record last time, we just didn't give him a copy. I'll place him under oath. Wait, no, don't need to do that? Mike? Okay.
Your Honor,
Yes.
could his mother and I give him a hug before he leaves?
Well, I guess my response to that is that I must treat him the same way that I treat everyone else in his position. At this point, we say, I'm sorry for help.
Sign copy, right here.
I have to make a couple of, those couple of typos on my order, and I'll make some typos when we get done.
Robert?
Thank you, Ms. Lindsay. Thank you, Mr. Dillard.
Thank you, Dad.
Mr. Evelyn.